Welcome to Talk Trials. We are back at the table, and today we are looking at a situation that feels a bit like a judicial suspense thriller that got paused right before the final act.
Right before the big reveal.
Exactly. Usually when we sit down to unpack Supreme Court arguments and opinions for, the legally curious, we are dissecting a clear decision, a yes or a no, a reversed or affirmed.
Right. The gavel bangs, the dust settles, and we can all sort of get a handle on what the new rules are.
But hey, today we are dealing with something else entirely. It's a procedural curveball that has massive, and I mean massive, constitutional implications. We are talking about Louisiana v. Callais.
It's good to be here. And curveball is, I think, putting it mildly, the Supreme Court has essentially hit the pause button on one of the most significant redistricting cases of the year.
A huge pause button.
Instead of issuing a merit decision, they've ordered the case to be restored to the calendar for re-argument. So they looked at the case, they heard all the arguments from both sides, and then they just said, you know what, let's do this again later.
Which, in the high-stakes world of the Supreme Court, is not exactly a common occurrence. I mean, not for a case that has already been fully briefed and argued. It feels like a glitch in the matrix.
It really does. It signals a deep hesitation or maybe a fracture within the court that they haven't quite resolved yet. But while the majority remains silent on why they're delaying this...
No explanation at all.
Zero. They offered no explanation in their order, but Justice Thomas did not stay quiet.
No, he did not.
He issued a dissent regarding this decision to delay, and that dissent is going to be our roadmap for today. He accuses the court of punting, and that's his word, not mine.
His exact word.
On a mandatory jurisdiction case, and that's a key phrase we're going to have to unpack.
Okay, so this isn't just about a calendar delay or some kind of administrative shuffling. This is about a map, specifically Louisiana's congressional map, which is known as Senate Bill 8 or SB 8. The core legal question here is the constitutionality of that map, which created a second majority black district in the state. But as we know with these cases, it is never just about the lines on the paper.
No, it never is. This case represents what Justice Thomas calls an intractable conflict. It's a powerful phrase.
Intractable.
It's the collision between Section 2 of the Voting Rights Act, the VRA, and the Equal Protection Clause of the 14th Amendment. Louisiana is essentially trapped in a vice grip between a statutory mandate to draw race-based lines to satisfy the VRA and a constitutional mandate to be colorblind to satisfy the Equal Protection Clause.
So our mission for this deep dive is to unpack that dissent. We aren't just skimming the surface here. We need to understand why Justice Thomas believes the court had no choice but to decide this now, why he thinks this delay is actively dangerous for the states, and why he claims the current president, and this is a big one, a case called Allen v. Milligan, is, in his words, broken beyond repair.
It's a heavy accusation. I mean, for a justice to say a recent precedent is broken beyond repair, that's throwing down the gauntlet. He's arguing that the court's current logic forces states into a Janus-like existence.
Janus-like? Okay, we are definitely going to spend some time on that image.
We are. It's the idea of looking two ways at once, unable to satisfy one master without betraying the other. It's a profound critique of modern election law and jurisprudence.
All right, let's get into it. Before we dive into the heavy constitutional theory, and trust me, we will get deep into the weeds of strict scrutiny and three-judge courts, we need to set the scene.
We have to. The facts matter.
We need to understand the geography and the procedural nightmare Louisiana found itself in. We're talking about Senate Bill 8. This was the map passed by the Louisiana legislature. So why was it passed? Because they didn't just wake up one morning and decide to redraw the lines for fun.
Far from it. This map was passed under extreme duress. You have to understand the timeline here, the sequence of events. There was a prior district court order from a completely different case called Robinson v. Ardorn.
A separate lawsuit.
Totally separate. That court looked at Louisiana's previous map and said, this violates Section 2 of the Voting Rights Act.
And just to clarify for everyone, Section 2 is the part of the VRA that prohibits voting practices or procedures that discriminate on the basis of race. It's the core of the modern VRA.
Correct. And specifically, the Robinson court ruled that because Louisiana has a black population of roughly 33%, but only one majority black district out of 6 total districts, that constituted vote dilution.
So the numbers just didn't add up in court's view.
Right. Their political power was being diluted, according to the court. So the court ruled that to avoid this dilution, Louisiana must create an additional majority black district. It wasn't a suggestion, it was an order.
So just try to picture this. You're a state legislator in Baton Rouge. A federal judge is holding a sword over your head saying, draw a second black district or you are breaking federal law. So what do? They go back to the drawing board and they enact SB 8.
They did exactly what they were told to do. The result is a map with 2 majority black districts out of 6.
Which is?
2 out of 6 is 33%. This tracks the black population proportion in Louisiana almost perfectly. On paper, it looks like problem solved.
On paper, yes. But the shape of this new district, this is where the visuals get really important. We aren't talking about a nice, compact square or a circle. The lower court that reviewed SB 8 described it in some pretty vivid terms.
They did. The 3-judge panel that eventually reviewed SB 8, this is the Callais court we're focused on today, noted that this new district stretches about 250 miles.
250 miles.
It creates a diagonal slash across the state. It goes from Shreveport in the northwest corner, specifically the Red River area, all the way down to Baton Rouge in the southeast.
For anyone who hasn't driven through Louisiana, that is a long, long haul. And culturally, those are 2 very different worlds. Shreveport is practically Texas. It's the Arklatex region.
Very true.
Baton Rouge is deep south. You've got the French and Caribbean influence, the capital city. Connecting them seems unnatural.
It is a very long drive and a very specific one. The court noted that the district slices through metropolitan areas to do one thing: scoop up pockets of predominantly black populations.
It's like a surgical instrument.
It is. It grabs parts of Shreveport, then it jumps down to Alexandria, then it veers over to Lafayette, and it finally ends in Baton Rouge. It essentially connects these disparate urban centers with a long, thin corridor, almost like a piece of string, to hit a racial target.
It sounds like connecting the dots, but the dots are cities, and the line is designed to capture a specific demographic. It's not about connecting people with shared economic interests or, shared regional identities.
Precisely. The dissent argues it ignores the traditional communities of interest, like shared economy, culture, or geography, and it replaces them with a single community of interest: race.
Okay, so Louisiana draws this map to satisfy the Robinson Court. They think, okay, we did it, we followed the order, we're in the clear. But then what happens?
Then comes the Callais litigation. A group of plaintiffs, including Philip Callais, sued the state. But here's the twist. They didn't sue under the Voting Rights Act. They sued under the Constitution.
Oh.
They argued that SB 8 is an unconstitutional racial gerrymander.
And this is the crux of the argument. They claimed that by prioritizing race above all else to draw that 250-mile slash across the state, Louisiana violated the Equal Protection Clause of the 14th Amendment.
Exactly. The Equal Protection Clause generally forbids the government from classifying citizens by race. So the Callais court, which remember is a different set of judges than the Robinson court, agreed with their plaintiffs. They looked at the map, they looked at the process, and they held that the map was a racial gerrymander.
And they had some pretty damning evidence to back that up, didn't they?
They did. This wasn't some subtle thing. They pointed out that key political figures openly admitted the primary purpose of SB 8 was to create a black district because of the Robinson litigation.
They just said it out loud.
They did. The sponsor of the bill was quoted saying, "We all know why we're here. We were ordered to draw a new black district, and that's what I've done."
That is surprisingly candid for a politician.
Yeah.
Usually they say, oh, we just wanted to respect county lines and keep communities together.
It's incredibly candid, but it underscores the state's position. They felt they had no choice. They were being honest about the gun to their head. But the Callais court ruled that a racial gerrymander is a racial gerrymander, regardless of the motivation.
So even if you have a good reason, or what you think is a good reason.
Right. Even if you are trying to comply with the VRA, you cannot violate the Constitution. The Constitution is supreme.
So let's recap this double bind here, because it's dizzying. You have the Robinson Court saying, you must draw this district to satisfy the VRA.
A federal command.
Then you have the Callais Court saying you cannot draw this district because it violates the Constitution.
Another federal command. Direct contradiction.
So what is a state supposed to do?
And just to add another layer of chaos to the whole thing, the Fifth Circuit Court of Appeals eventually vacated the original Robinson order.
Oh, wow.
But by then, SB 8 was already law. So now, Louisiana has a map that was passed to satisfy an order that no longer exists, and a new court order saying the map they passed is illegal.
It's a mess, a complete and utter mess.
It is a complete legal train wreck. So Louisiana appeals to the Supreme Court, basically pleading, please tell us what to do. Can we draw this map or not? Just give us a clear answer.
And that brings us to the dissent. The Supreme Court majority said, let's re-argue this later.
Yeah.
And Justice Thomas said, absolutely not.
Right. Thomas's dissent is grounded first in procedure, but it quickly, and I mean quickly, moves to the existential crisis of election law. His first point is about jurisdiction. He cites a statute, 28 U.S.C. Section 253.
Okay, we need to pause on this because Section 1253 sounds like dry legal noise, but it's actually a specific alarm bell Congress installed in the system for moments just like this.
That's a great way to put it. It's an alarm bell. Usually the legal system is like a ladder. You start at the district court. If you lose, you can climb to the Circuit Court of Appeals. If you lose there, you can ask the Supreme Court to hear you. And they have what's called certiorari jurisdiction, meaning they can say yes or no. They have discretion.
They could look at a case and say, nah, we're busy, or this isn't important enough for us to weigh in on. Most cases, in fact.
The vast majority. But Section 1253 is different. It governs cases heard by a special three-judge district court. Congress created these special courts specifically for certain types of important cases, including redistricting cases.
And the statute says what exactly?
The statute says that for these cases, there is a right to appeal directly to the Supreme Court.
It's an express elevator, straight to the top floor, no stops in between.
It is. Congress looked at redistricting, which, determines who holds power in our democracy for a decade, and said, we cannot let these cases languish in the appellate system for years.
Because the damage is done.
Exactly. If you let a bad map sit for an election cycle, you have arguably stolen an election. The results can't be undone. So they built a direct line to the Supreme Court and said, you must hear these.
So Thomas is arguing that the court's jurisdiction here is mandatory. It's not optional. They don't have the option to punt.
Yes, that's his first major point. He points out that despite the case being fully briefed and fully argued, the court punts without explanation. He notes that these are the only cases argued this term where jurisdiction is mandatory.
That's a powerful detail.
It is. He implies that the court is shirking a statutory duty by delaying. It's a very pointed criticism of his colleagues.
He also brings up some history regarding the 1976 amendments. What's the significance there?
Well, back in 1976, Congress actually got rid of a lot of these three-judge courts because they were, frankly, clogging up the system and being used for things that weren't that important.
A bit of a procedural house cleaning.
Exactly, but they specifically kept them for redistricting. Thomas argues this was a clear signal. Congress understands that election maps are uniquely time-sensitive. They wanted, in his words, expedited Supreme Court correction. By delaying, Thomas argues, the court is essentially rewriting the statute to give themselves discretion where Congress gave them none.
So that's the procedural gripe. You are ignoring the express elevator. You're breaking the rules Congress set for you. But the real heat in this dissent, the real philosophical firepower, comes when he describes the Janus-like nature of the jurisprudence.
This is the core of his argument. Janus,
The Roman god.
the Roman god of doorways, of transitions, and of duality. He's always depicted with two faces looking in opposite directions. One looks to the past, one looks to the future. Thomas argues that the court's precedents have forced states into this Janus-like posture.
Okay, break that down for us. How so?
Well, one face looks toward the Voting Rights Act. The VRA, specifically Section 2, as it's been interpreted, demands that states look at race. It forces them to. It asks, are you representing minorities? Are the numbers proportional to the population? It forces the state to be race conscious.
So that's face number one. It's looking at race. It's counting by race. And the other face.
The other face looks toward the Constitution, specifically the 14th Amendment's Equal Protection Clause. That amendment was written to erase the stain of slavery and ensure equal protection under the law for all citizens, regardless of race. It demands colorblindness.
It asks, did you sort citizens by race?
And if the answer is yes, you are in deep constitutional trouble.
So you have one law whispering in your ear, look at race, count by race, and the supreme law of the land screaming, don't look at race, don't you dare sort people by race.
And Thomas says you cannot do both. You cannot be colorblind and color conscious at the exact same moment. It is, to use his term again, an intractable conflict.
And Louisiana's defense in this case was explicitly built on this, right? They essentially went to the court and said, we're tied in knots here, help.
They did. They argued that their defense was intertwined. They told the court, essentially, you cannot judge our map under the Constitution without also judging the VRA order that forced us to draw it in the first place.
Their argument was, if the Robinson order was a valid command under the VRA, then the map we drew to comply with it must be valid under the Constitution. One has to follow the other.
Right. How can an action be both legally required and constitutionally forbidden at the same time? It's a paradox.
And Thomas takes a very hard line here. He doesn't just describe the problem, he offers a solution. And he reaches back to the greatest hit of 1803, Marbury v. Madison.
The foundational case. He states the principle: the Constitution is supreme over statutes. It is the first rule of American law. Thomas is laying down a marker. He is saying that the Voting Rights Act is just a statute. It was passed by Congress.
An incredibly important statute, but a statute nonetheless.
Absolutely. But the 14th Amendment is the Constitution. It was ratified by the people through a much more arduous process. If the VRA is being interpreted in a way that requires a state to violate the Constitution, then that interpretation of the VRA must yield. The statute has to give way to the Constitution.
It sounds so simple and fundamental when you put it that way, but the implications are massive. If the VRA requires something unconstitutional, then the VRA application is void. This isn't just about Louisiana. This is about redistricting in every state with a significant minority population.
It is. And this leads us to his specific pointed attack on a very recent precedent, Allen v. Milligan. This case was just decided in 2023.
Now, Milligan was a huge surprise to a lot of court watchers. The court, in a 5-4 decision with Chief Justice Roberts and Justice Kavanaugh joining the liberals, upheld a VRA claim in Alabama, essentially preserving the status quo of how we look at these vote dilution cases.
It was a shock. Many expected the court to curtail Section 2. Thomas dissented in that case, and he is doubling down here. He argues that Milligan is the source of this direct conflict. He says Milligan placed the VRA on a collision course with the Constitution by effectively mandating proportional allocation of political power according to race.
He calls it a proportionality trap.
A great phrase. Under the Milligan framework, the test involves asking a series of questions. Is the minority group large enough and geographically compact enough to form a majority in a reasonably configured district?
Okay.
If the answer is yes, and if voting in the state is racially polarized, meaning white voters and black voters tend to vote for different candidates, and if the current map doesn't have a proportional number of minority districts, then you likely have to draw the district.
So if a minority group is 30% of the state's population, they should get roughly 30% of the congressional seats, provided you can draw a reasonable map to do it.
That is the practical effect of the ruling. And Thomas argues that this turns the VRA into a machine for proportional representation, which, by the way, Congress explicitly said it wasn't supposed to be when they passed it.
And he brings up this phrase, the reasonably configured standard. This is where we have to talk about technology, because drawing a map in 1965 or even 1982 is very, very different from drawing a map in 2025.
This is a fascinating part of the dissent, and I think it's where he feels the law hasn't caught up with reality. The Milligan test asks if a second black district can be reasonably configured. Thomas argues that in the modern era, this standard has become meaningless because of computers.
Explain that. What does he mean?
Well, think about it. If I ask you to draw a map by hand that connects Shreveport to Baton Rouge while picking up specific neighborhoods in Lafayette and Alexandria, that would be really hard. You'd have to look at census tracts, you'd be there with a pencil and paper, it would be a mess.
It would look like a gerrymander because it would be so obviously contorted.
Exactly. But with modern computing power and mapping software, drawing these maps is, in his word, perfunctory.
You just feed the data into the algorithm.
Precisely. You tell the computer, objective, create 2 districts with 50.1% black voting age population. Constraints, must be contiguous. Go. The computer will run millions of simulations in seconds and spit out thousands of maps that technically meet the criteria.
It's like asking an AI to write a sonnet. It doesn't know what love is. It just knows the math of the words and the structure. The computer doesn't know what a community is. It just knows the math of the census blocks.
That is a perfect analogy. Thomas argues that relying on these computer models allows for palpable racial gerrymanders to pass the legal test. Just because an algorithm can find a way to snake a district through the state to hit a racial target doesn't mean that district represents a real cohesive community. It's just a data set shaped to fit a legal requirement.
And if the courts say, well, a computer found a way, so you have to do it, they are essentially handing the pen to the algorithm. They're outsourcing the judgment of what's reasonable.
And the algorithm has been programmed to prioritize race above all else. So the VRA, in this view, becomes a tool to maximize racial separation in politics, justified by the supposed objectivity of a machine.
There's also a really sticky subject Thomas raises in a footnote. It's about racial polarization. This is really the elephant in the room for so much of American politics.
It is. To win a VRA case, plaintiffs have to prove that the white majority votes as a bloc to usually defeat the minority's preferred candidate. This is called racially polarized voting.
But in the American South, and increasingly everywhere else, voting is also highly partisan.
And that's his point. Thomas notes that racially polarized voting is easy to establish in the courts. But he cites an expert who admitted under oath that actionable racially polarized voting has only been found to exist where whites tend to vote for Republicans.
So it conflates race with party. It's impossible to untangle the two.
Thomas argues it does. If black voters overwhelmingly vote for the Democratic Party and white voters in a region overwhelmingly vote for the Republican Party, is that evidence of racial hostility preventing black voters from electing their candidate of choice? Or is it just partisan politics playing out? Thomas suggests that what the courts are labeling racial polarization is often just plain old partisan voting behavior.
And if the VRA forces the creation of majority-minority districts based on this data, it's effectively mandating the creation of safe Democratic districts.
That is the clear implication. He argues that by forcing these districts, the VRA becomes a tool for allocating political power not just by race, but by party, all under the guise of civil rights protection. He believes the federal courts are immersing themselves in questions of political theory that they have no business deciding.
This all leads to what I'll call the justification gap. This brings us back to core constitutional law. We need to talk about strict scrutiny.
The highest level of judicial review, the toughest test in constitutional law.
Whenever the government sorts people by race, whether it's for affirmative action in university admissions or for redistricting, the court applies strict scrutiny. And to pass, the government must show two things.
First, a compelling governmental interest. And second, that the action is narrowly tailored to achieve that interest.
And usually, the only compelling interest the court has recognized when it comes to race is remedying specific identified instances of past discrimination.
Right. Not just the general sense that society was racist 50 years ago, but this specific barrier exists right here, right now, and this policy is designed to fix that.
But Thomas argues that the current VRA application is totally divorced from that remedial justification.
Yes. He argues that post-Milligan, the VRA forces race-based redistricting even when there are no specific instances of discrimination being remedied. It's just maximizing the number of minority districts for the sake of maximization. It's outcome-based, not remedy-based. The goal becomes racial proportionality itself.
He uses a specific, very concrete example to prove this point. A map maker named William Cooper. This guy seems to be the smoking gun in Thomas's narrative.
He is. He's a central character. William Cooper was an expert cartographer who drew maps for the plaintiffs in both the Milligan case in Alabama and the Robinson case in Louisiana.
So he's the go-to guy for drawing these illustrative maps.
He is. And Thomas points out that Cooper freely admitted, under oath, to prioritizing the minority population as the paramount community of interest.
So he basically confessed to racial gerrymandering. He said, I started with the racial data, I drew this map to hit a racial number.
Yes. And yet, under the Milligan analysis, his maps were accepted by the lower courts as the illustrative plans used to prove that the state's map was illegal. Thomas is highlighting what he sees as a profound absurdity.
It's a circular loop.
It is. The plaintiffs use a racially gerrymandered map to prove the state violated the VRA by not drawing a racially gerrymandered map, and then the remedy is to force the state to enact a racially gerrymandered map.
It is a loop that Thomas says is broken beyond repair. He argues that you cannot use a statutory violation to justify a constitutional violation. If Mr. Cooper's map violates the Equal Protection Clause because it prioritizes race above all else, it shouldn't be used as evidence for anything. It should be inadmissible.
It taints the entire process from the very first step.
Broken beyond repair. That is such strong language for a Supreme Court justice. He isn't saying we need to tweak the test or clarify a standard. He is saying the engine has fallen out of the car.
He is. He says the court faces a stark choice. Either they permit patent racial gerrymandering under the guise of VRA compliance, or they admit that a Section 2 violation, as currently understood, is insufficient to justify a race-based remedy that violates the Constitution. He believes the court is avoiding this necessary but very difficult confrontation.
And the impact on the states while the court avoids this confrontation. While they punt and restore a calendar, what happens on the ground?
Chaos. Absolute paralysis. As long as this intractable conflict exists, states literally do not know how to draw a legal map.
Explain that from the perspective of a legislator.
Okay, imagine you are the committee chair in Louisiana State House. You sit down with your staff to draw a new congressional map. If you draw a race-neutral map that follows county lines, keeps cities whole, and ignores race entirely, what happens?
You will get sued under the VRA because you didn't create enough black districts to satisfy the proportionality logic of Milligan.
Guaranteed. So you lose that lawsuit. Okay, so next time you draw a race-conscious map, you learn your lesson. You connect Shreveport to Baton Rouge to make sure you have 2 black districts. Now what happens?
Then you get sued under the Constitution for racial gerrymandering, and you lose that lawsuit in a different court.
So you get sued either way.
You get sued either way, and you will likely lose in one court or the other, depending on which panel of judges you draw. By setting this case for re-argument, the court ensures this confusion persists for another election cycle. It leaves the state legislatures defenseless against endless litigation.
It essentially means the judiciary is drawing the maps because the legislature is paralyzed by contradictory mandates. Federal judges become the ultimate map makers, district by district.
Precisely. And Thomas is arguing that we have lost the plot. The Constitution was meant to prevent the government from classifying citizens by race. The VRA was meant to stop discriminatory practices that were preventing people from voting. But now, he argues, the VRA is being used to mandate racial classification. He believes we have inverted the hierarchy of laws.
The tool has become the master.
That's a good way to put it. And this brings us back to the start, the punt. Thomas says there is no reason to delay. The conflict is here, it is clear, and it is the court's job to resolve it.
He ends on a very somber note, actually. It's almost weary. He quotes his own opinion from decades ago, saying he has called for a systematic reassessment of Section 2 for over 30 years. He calls the Milligan decision a disastrous misadventure. He is hopeful, he says, that the court will eventually wake up to the severity of the conflict, but he is clearly frustrated and disappointed that it isn't happening today in this case.
It is a powerful dissent, and it lays bare the tension at the heart of American election law right now. We are trying to reconcile a history of discrimination with a mandate for colorblindness. And the math just isn't adding up.
And until the Supreme Court decides which mandate takes precedence, the statute's command to be race-conscious or the Constitution's command to be colorblind, we are going to see the same lawsuit in different states over and over again.
Well, that is the analysis of the dissent. We have walked through the geography of Louisiana, the procedural trap, the Janus metaphor, and the constitutional crisis that Justice Thomas has laid out. But now we have to do what the Supreme Court majority refused to do.
Yes.
It's time for us to take a stand.
Indeed. The docket is clear.
I am handing the gavel to you. It is time for the 10th chair.
Sitting at the 10th chair, the following represents Talk Trial's independent reasoned analysis based on the facts presented.
The case is Louisiana v. Callais. The question before you is not the merits of the map itself, but the procedural question. Whether to set the case for re-argument or decide it on the merits immediately. How do you rule?
We would reverse the court's order to set the case for re-argument and instead proceed to decide the case on the merits immediately.
And what is the reasoning, the ratio decidendi for that judgment?
The reasoning rests on 3 essential pillars. First, jurisdiction is clear and mandatory. We agree entirely with the dissent that under 28 U.S.C. Section 253, the court has a statutory obligation to hear appeals from 3-judge district courts in these specific redistricting cases. Punting violates not just the letter, but the spirit of the law. Congress explicitly signaled that these cases cannot wait because they determine the very legitimacy of our elections. The court should honor that mandate, not evade it through procedural delay.
Okay, that's pillar number 1. Follow the statute. What's the second?
The second is the ripeness of the conflict. The clash between the Robinson Court's VRA mandate and the Callais Court's equal protection violation creates an utterly impossible situation for the state of Louisiana. This Janus-like state of affairs requires immediate clarification from the nation's highest court. The state is currently operating under a cloud of illegality no matter which direction it turns. It is the core role of the Supreme Court to clarify federal law when lower courts are issuing contradictory commands. Delaying serves no valid legal purpose. It only prolongs the chaos and undermines faith in the rule of law.
And the third and final pillar.
Constitutional supremacy. This is the most important one. We must adopt the logic that where a statutory interpretation, specifically Milligan's reading of VRA Section 2, forces a state to violate the Constitution's Equal Protection Clause, the statutory interpretation must yield. The Constitution is the supreme law. The court should have used this case as the vehicle to clarify that Milligan cannot be read to compel racial gerrymandering that otherwise violates the 14th Amendment. If a map like SB 8, which slices through 4 cities over 250 miles to grab specific racial pockets, is what the VRA requires, then the VRA is being applied unconstitutionally. That conflict must be resolved in favor of the Constitution.
And finally, sitting as the 10th chair, what is the projected impact of your ruling to decide the case now?
Deciding this now would force a direct reconciliation of Allen v. Milligan and the long line of racial gerrymandering cases that started with Shaw v. Reno. It would likely narrow the scope of the VRA's effects test, making it harder to force states to draw non-compact race-predominant districts. It would tell states that their primary obligation is to the Constitution's command of equal protection, not to a computer algorithm's ability to maximize racial proportionality. Delaying, on the other hand, only ensures that lower courts continue to issue these contradictory orders, leaving state legislatures essentially defenseless against endless bankrupting litigation from one side or the other. A decision now would restore the primacy of the Constitution and provide states with the clear guidelines they desperately need to conduct their elections.
A decisive ruling from the 10th chair.
The law abhors a vacuum, and right now, Louisiana's election law is stuck in one. It is time to turn the lights on.
Well, that wraps up our deep dive into the legal limbo of Louisiana v. Callais. Louisiana is stuck between a VRA rock and a constitutional hard place, and for now, the Supreme Court has left them there.
Justice Thomas has sounded the alarm that the VRA and the Constitution are on a collision course. The majority has tapped the brakes, but the crash seems inevitable eventually.
Before we go, here is a final provocative thought for you to chew on. We talked a lot about computers and algorithms today. If modern computing allows mapmakers to generate thousands of reasonably configured racially proportional maps in a matter of seconds, has technology rendered the traditional compactness requirement of the VRA essentially meaningless?
It forces us to ask, is a district compact because it looks nice and neat on a computer screen, or because it actually holds a real human community together?
And is it even possible to draw any map today that isn't in some way an intentional choice about racial allocation when the algorithms know everything about us? If the machine knows your race, your party, and your zip code, is colorblindness even a technical possibility anymore?
Or is every map just a reflection of the bias we program into the code in the first place?
Something to think about. Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Supreme Court.
Indeed. These are complex issues, and we are just here to help you navigate them.
Thank you for listening. We will see you at the next session.